My name is Mary Grover, and thank you for coming. I hope you learn a lot from Rich Robinson, our guest speaker, and from the handouts that we have for you. I always see these programs as a teachable moment, and I want you to scoop up the handouts, take it home, leave it on the breakfast table, let your kids and family see it, and read it and look it over. This program is sponsored this evening by the League of Women Voters of the Grand Traverse area and the Grand Traverse Leelanau Antrim Bar Association and the Joyce Foundation, which is the sponsor or funder of Michigan Campaign Finance Network. Now, I have to tell you this, League, because we do this every time. The League is a national, nonpartisan political organization that encourages the informed and active participation of citizens in their government. We don't endorse or oppose candidates or parties, but we do make an effort to obtain factual information on candidates' views and ballot issues, and we distribute this information as widely as possible. Now, let me give you just a little history about the concern of the League in the Grand Traverse area and the Bar Association, the concern about money in Michigan Supreme Court candidates' races, and about creating an independent judiciary. Keep your speaker busy. In May 2007, the Omelet Shop group was formed at the Omelet Shop on Munson by the Birdseed store. And we gathered around to talk about our concerns over the Nestle case that came out of Mecosta County that Jim Olson was then litigating, and about the 2004 Cleveland Cliffs case from the UP. At the table were members of the League of Women Voters and the State League, local and state league, the Northern Michigan Environmental Action Council, the Leelanau Independent Women for Democratic Action, and the Michigan Campaign Finance Network. Ta-da! In both the Nestle and the Cleveland Cliffs cases, the Michigan Supreme Court weakened Michigan's Environmental Protection Act from 1970 that was passed while our own Milligan was governor. At that May 2007 meeting, Rich Robinson persuaded us that the overriding issue that we should be concerned about was campaign financing for Michigan appellate and Supreme Court candidates and the overriding need for an independent judiciary. In October, following that meeting, the League and these other groups in the Grand Traverse Leelanau Antrim Bar Association sponsored an informational program about campaign financing for Supreme Court candidates, and Rich was one of the speakers. In February 2008, we filled the bus and took petitions signed by hundreds of people from the Grand Traverse area to Lansing to present to then State Senator Michelle McManus, who was then chair of the Senate Campaign and Election Oversight Committee. We were begging her, asking her to please do something about disclosure, campaign finance, something. Sadly, nothing happened and nothing changed. Nevertheless, Rich Robinson, the League, and the Grand Traverse Leelanau Antrim Bar Association are still at it, and even though it's worse now, as we shall hear from Rich. Now let me tell you a little something about him. He grew up in the UP, in Sault Ste. Marie, and he now lives in the UP part-time and in Lansing the rest of the time. He was a Peace Corps volunteer. He has a BS, MA, and Master of Public Policy from the U of M. In 2001, just to check your alertness. In 2001, he became executive director of the nonpartisan Michigan Campaign Finance Network. And in 2012, Rich Robinson was project assistant to the Michigan Judicial Selection Task Force. Today, Rich Robinson is Michigan's go-to guy for investigating and reporting on campaign expenditures in Michigan, and the story's getting grimmer. With the passage of Citizens United versus the Federal Elections Commission, it's pretty much the Wild West of undisclosed campaign finance at all levels. We'll hear about it. Thank you so much. Rich.
Well, all of that is to say that political reform is not for the short-winded, and if you're going to be wandering in the desert, have a friend like Mary Grover. It's great to be here. Thank you for coming out. It's great to see old friends and new friends, and this isn't a pretty story, actually, and I think it is, in fact, getting worse. And I'll try to give you a sense of what exactly is going on and some sense of hope about a different approach to doing something about it. So can we dim just the first row of lights? Will that mess up your work?
First
Rich?
two on the left, Mayor.
Thanks.
Terrific, that should help. This slide represents Supreme Court campaign finances over the last 30 years. And this is actually a good slide because you don't need to see the numbers. The shape and the size of the bars will tell the story. The blue part of the bars are what the candidates have raised in their own campaign committees for these Supreme Court campaigns over this period. The red represents independent expenditures by the political parties and political action committees that are reported through the state campaign finance disclosure system. And the white part of the bar represents television, quote unquote, issue ads that are not reported in the state's disclosure system. The methodology for putting a size on that part of the bar is I collect the data from the broadcasters and the cable systems around the state who maintain a public file of the records of political advertising that goes on in their various stations. Now, in my mind, there's kind of a pre-modern era that really ended in 1994. And at that point, that whole campaign probably amounted to less than $1 million. In 1996 was the first year that the political parties got involved making independent expenditures. 1998 was the first year of $1 million candidate committees. Cliff Taylor raised just less than $1 million that year. Maura Corrigan raised just over $1 million that year. Then in 2000, the game really changed altogether. This was the first time that the candidate-focused issue advertising became a part of the game. And I kind of went out of my mind that year because over half the money spent in the campaign was for issue advertising, or just around a half. It was $7.5 million. Now, the situation that year was that there were 3 Engler appointees on the ballot. It was not the first time facing the electorate for Cliff Taylor. He had in 1998 to complete the term to which he had been appointed, was then running for a full term. The others were facing the electorate for the first time. The majority on the court was at stake, and so it brought out a lot of competition. Now, you might say, wait a minute, this is a nonpartisan court. What do you mean the majority was at stake? And at this point, for the uninitiated, I'll describe what I lovingly call the Immaculate Reconception. The candidates are nominated by the political parties at their fall conventions, and miraculously, they come back as nonpartisans on the general election ballot. So, in fact, it was a case where the court at the time was 5-2, but if the Democrats ran the table, they could switch the majority. They did not. They lost everything. In 2002, 2004, 2006, there really wasn't much chance of tipping the majority because you had pretty well-established incumbents running, and particularly in 2004 and 2006, it wouldn't have been possible to flip the majority because you had one Democratic incumbent running and one Republican incumbent. 2008 was just a single seat. That was the year that Diane Hathaway, now gone from the court, defeated Cliff Taylor. That was the first time an incumbent Supreme Court justice had lost an election since 1984. So it's a relatively uncommon occurrence, although it happened again in 2010 when Justice Betty Weaver resigned in August. Tom Davis, who was a Court of Appeals judge from Grayling, was appointed to the court, ran as an incumbent, lost that election. But again, in both of those years, over half the money spent in the campaign was not reported through the campaign finance disclosure system. Now, we go to current times, 2012, and I'll show you a summary there in just a moment, but the gist of it is the candidates raised $3.4 million. There is a total of $1.1 million reported independent expenditures, and there was just less than $14 million of unreported independent spending for television quote-unquote issue ads. That's what I can document. That's a conservative estimate of what the whole spending was. For example, I have in my possession 13 different direct mail pieces that the Michigan Republican Party sent out. They're not acknowledging any of them. They do acknowledge some direct mail. They don't say who it supported. I'm taking that it was about the Supreme Court candidates, but they're not recognizing that because, I guess, they also had the names of the candidates for the various university governing boards and the State Board of Education. So because of that diffuse kind of support, they're not pinning it down. Nonetheless, that does not account for all 13 of these pieces, which is only to say I'm giving you a lowball number in what this all amounted to. So the long and short of it is that this time around, barely, well, actually less than 25% of all the money that was spent is reported through the campaign disclosure system. Now, why does that matter? In the first place, we should have a right to know who's spending money in these campaigns, just for the basic facts of who's supporting the candidates. But there's another element of it when you're talking about particularly an appellate judicial campaign, and that is what I'll call or refer to as a shorthand, a Caperton problem. Now, in order to describe what that is, I'm going to have to take you into a Supreme Court case, and that was the case of Hugh Caperton against Massey Energy, Massey Coal Company. Hugh Caperton was a smallish coal operator in Virginia, West Virginia, Western Pennsylvania. Massey Energy was one of the giants of the industry. They offered to buy him out. Then they slow-walked the whole thing until his contracts expired, and then they reneged on the offer, trying to come in and pick up those contracts. Caperton sued, won on the business fraud case, and was awarded a $50 million damage judgment by the jury. That was upheld in the West Virginia Court of Appeals before it got to the West Virginia Supreme Court. In the intervening time, there was a Supreme Court election. And one of the candidates was the incumbent Chief Justice. He was attacked by a group called And for the Sake of the Children, accused of being soft on pedophiles. It turned out that the chief executive officer of Massey Coal Company personally gave $3 million to And for the Sake of the Children. This is a guy named Don Blankenship, who later became famous for explaining a fatal mine disaster where I think 29 miners were killed as the result of a lightning strike, not the chronic safety violations and methane leakage in the mine, but lightning. Ultimately, Massey has now been sold to some private equity firm who operates their legacy. In addition to the $3 million Blankenship gave to And for the Sake of the Children, he bundled $2 million more from associates and friends, and essentially was the entire campaign behind Brett Benjamin, who won that election. So, Hugh Caperton's case gets to the West Virginia Supreme Court. His attorney asks Justice Benjamin to recuse himself because essentially his whole campaign had been financed by one of the litigants in the case. He refused twice. Caperton petitioned the U.S. Supreme Court. They took the case and in a 5-4 decision said Benjamin had to get off of that case. There was the appearance of a conflict of interest there. They didn't say where the bright line was. They said this is across the bright line, wherever that is. So that's the problem here, because when you have $14 million coming into a campaign that's unaccountable, can't be traced to any source, the problem is what that may well conceal is the interest of a party who has a case in the appeals pipeline. And the opposing litigant should have a right to know that. That could well conceal a justifiable recusal motion. So that's the additional peril when you get into these appellate judicial campaigns. So these are the numbers behind that bar graph. I'm guessing you probably can't see them very well. But I'll tell you this.
It's on the yellow sheet.
Oh, it's on the yellow sheet, so I hope you've picked that up. There is the bottom line in the modern era here, a percentage of what I could document the spending to be that was part of the state's disclosure system. And you see it ran 50% plus or minus until we got to 2012, and it's now down to 25%. Over this period from 2000 to 2012, a little better than $60 million spent to elect 15 justices, and 34.7 million outside the disclosure system. So we've got over half the money for that long period off the books, 3/4 of the money off the books in 2012, and to the point I'm trying to make, this hidden problem of a Caperton issue is just getting bigger as time goes on. So here, and I think this is also in your yellow handout, is a summary of the 2012 campaign, what the candidates themselves raised, what was reported by the political parties, interest groups. For example, and this is one thing, well, and I guess the point I didn't make that I should have made is this whole dark money problem, this element of undisclosed spending, predates the Citizens United decision. We had this thing going on long before Citizens United, and it's just festering now. But one thing that I can point to in this particular graphic is a Citizens United element. And that is, you see a line for the Michigan Association of Realtors. They spent $400,000 on radio advertising in this campaign, and these are separated by those that were supporting the Republicans, opposing the Democrats, and those that were supporting the Democrats, opposing the Republicans. When they disclosed this, the Michigan Association of Realtors had established for themselves a super PAC, just like the big league super PACs, Restore Our Future and all of that. But their difference was they said the money came from the nonprofit corporation, the Michigan Association of Realtors. So not really much transparency there. We're not saying where it came from. And then on the far right there, you see this is who sponsored the television quote-unquote issue advertising. The Michigan Democratic Party for $6.2 million, the Republican Party $6.7, and the Judicial Crisis Network for $1 million. The Judicial Crisis Network is a DC-based nonprofit organization that was formerly known as the Judicial Confirmation Network. It was first established at the time of the confirmation hearings for Clarence Thomas, and since that time had been known as a supporter of Republican nominees to the U.S. Supreme Court and an opponent of Democratic nominees. It morphed this year into a vehicle for somebody's money, essentially a money laundering shell, to take the fingerprints off the true donor in this case, and I have no insight whatever as to whose money they were using. This is just to illustrate how the money was spread across the television markets around the state. You see, in a fairly typical pattern, about 45 to 50% is usually in the Detroit market, because that's where about 45% of the population is. Grand Rapids, Kalamazoo market takes up about a quarter. I don't know if you knew that Traverse City is now a more important media market than Lansing and frequently Flint, Saginaw. And I think that has to do about the perception of persuadable voters in all these respective markets. Republicans don't spend much money in the Flint-Saginaw market. They don't think they're going to persuade much of anybody in those markets. So this is just a curiosity then. The one other thing that I'll point out on this slide is that Judicial Crisis Network was only active, only ran their ads in the Detroit media market in Grand Rapids. So let me say this about issue ads. There are supposed to be, in a definition that was given to us by the United States Supreme Court in a case called Federal Communications Commission against Wisconsin Right to Life, that an issue ad is an attempt to mobilize viewers, listeners, to contact a public official who can act on a matter. In the brief of the appellate lawyer in that case, one Jim Bopp, who has the avowed goal to eliminate all campaign finance regulation, this was grassroots lobbying. Now, how is it that none of this stuff is reported to the state? Well, the state was asked for a declaratory ruling after the McCain-Feingold reforms about whether that ban on federal spending in, or corporate spending, and unions are corporations, in federal elections would have any effect on how Michigan campaigns were conducted. This was requested for by the Michigan Chamber of Commerce. And the answer from the Secretary of State at the time, Terry Land, was that you know, there's a vagary here, and we're going to stick to a standard of express advocacy. Now, this goes back to a Supreme Court case called Buckley against Vallejo that was the litigation after the Watergate reforms. And essentially, there's a footnote in that case that says the words vote for, vote against, support, oppose, or the like must be present in order for something to be express advocacy. Otherwise, it's issue advocacy. So in this interpretive statement from Secretary Terry Land, she said, we're going to stick with that standard for what is a campaign expenditure and must be reported, and everything else that isn't, presumably some kind of educational message. Well, Wisconsin Right to Life was concocted by Jim Bopp to test the McCain-Feingold prohibition against corporate money in the window immediately before an election. And the test went like this. we've got an ad that says, Russ Feingold, who was running for re-election in Wisconsin as a U.S. Senator in 2004, stop filibustering judicial nominations. Now, never mind that the U.S. Senate was in recess and Feingold wasn't filibustering judicial nominations. It was a perfect test case because it clearly had nothing to do with an election. And the U.S. Supreme Court said, well, we can't bar that corporate speech. And so this was the beginning of the unraveling. And in fact, Scalia wanted to take it farther, and in a footnote, he accused Chief Justice Roberts of faux judicial modesty. Quite an insult in those pristine circles, and said we really ought to be letting people say whatever they want, no matter who they are. They got there a little bit later. But the court did a couple things. They said there is a functional equivalent of express advocacy. That is, you don't literally have to have those words, vote for, vote against, to effectively be a campaign ad. And we're going to tell you what authentic issue advocacy is, and that's this business of contacting a public official who can act on a matter. Now, I want you to consider the fact that in the state of Michigan, judges are not lobbyable officials. So how is it your ad can be lobbying a judge who's not lobbyable, and that's the excuse for putting it outside the category of having to be reported as a campaign expenditure? That's the question I ask. So as you look at these next few ads, keep in mind that standard that this is supposed to be about, not about the candidate's qualifications for office, their record, their campaign, their opponents, but it's about an issue somehow. And that's why it's outside of reporting.
Because they can't run for judge, we need our judges to stand up for them. Judge Connie Kelly, Judge Sheila Johnson, and family advocate Bridget McCormick are three candidates for Michigan Supreme Court who've spent their careers protecting families and victims of crime. From getting criminals off our streets to keeping kids out of gangs. And unlike some judges, they have zero tolerance for violence against women and kids. Kelly, Johnson, McCormick, these three protect families.
Now, the spot tells you they're candidates for the Supreme Court, and yet this is not about the Supreme Court election, in theory. Pretty much saccharinely sweet, and I put this in to dispel the idea that these are all attack ads. They're not always. The object here was positive name identification. Here's a Republican reply to that ad.
Johnson, Kelly, McCormick, tough on crime? Hardly. Johnson, Kelly, McCormick had the wrong priorities to protect Michigan families. Johnson has a record of questionable judgment, putting communities at risk. McCormick volunteered to represent terrorists at Guantanamo Bay and fought to protect sexual predators. And Kelly is a former appointee of scandal-ridden Wayne County Executive Bob Bacano. Tell Johnson, Kelly, and McCormick that Michigan families need judges to protect them, not criminals.
Just one technical detail here, that family advocate Bridget McCormick fought to protect sexual predators. Well, she's a professor at the University of Michigan running the Innocence Project, and using DNA evidence, they were able to reverse a conviction of someone who was wrongly convicted of a sex offense. But that's a detail that really doesn't make it into a campaign ad. So and now this is one I'm guessing you probably didn't see. This is the offering from the Judicial Crisis Network.
June 16th, 2010, the day our life was shattered. My son Joe was taken from me, killed when his unit was attacked by terrorists in Afghanistan. My son selflessly gave his life for this country. So when I heard Bridget McCormick volunteered to represent and help free suspected terrorists, I couldn't believe it. My son's a hero and fought to protect us. Bridget McCormick volunteered to help free a terrorist. How could you?
Again, there are details missing, like the fact that there were bounties on picking people up off the battlefield and bringing them in as terrorist combatants in Afghanistan at the time we were populating Guantanamo, but never mind with details like that. That's not the narrative we want here. The point, though, I think with this is these commercials are about the qualifications or suitability to hold office of these people. They're not where you're trying to get an official to act on an issue. There's a disconnect there. And again, as I say, judges just plain old are not lobbyable officials under Michigan law. And I think this brings up what I would like to submit to you as a cause for a bit of optimism. I think this is right now for a request for a new interpretive statement that says, look, you're missing some very important U.S. Supreme Court jurisprudence since that last interpretive statement that's governing what's in and what's out as a campaign expenditure. And I intend to do that. I'm floating different ideas, and my hope is that we will test this very soon. And if we don't get a favorable ruling, then Secretary of State is going to have really around her neck the fact that she is an enabler of this dark money. Now, to me, the law is relatively clear here, and we'll see how this comes out. This slide, it really wasn't the Oakland County 6th District Court, it was the 6th Circuit Court. And I think this might be on your yellow handout too. Now, I put this slide in front of you to illustrate the fact that this pathology of dark money and judicial campaigns has now worked its way down into a trial court campaign in Michigan. This was a campaign where there were 5 incumbent judges on the Oakland County 6th Circuit Court running for re-election. 2 challengers, who both happened to be assistant attorneys general, entered the race as challengers. And the total of all of this, between what was raised in cash by the candidates and their in-kind contributions, was just over $720,000. And at the same time, there was $2 million spent for more issue advertising. Again, 3/4 of the money off the books. Now, this one has provoked a lot of outrage in Oakland County. And I think the reason is this. You know, when I tell you that over a period since 2000, there's been $35 million worth of this dark money spending, it's fairly abstract because we really don't know much, if anything, definitively about whose money it was. This Oakland County thing is a little bit different in that I think every lawyer, judge, and reporter in Oakland County thinks they know who it is, whose money it was, an individual. And it was a scenario where I don't like the decision you made, I'm going to take you out, I'm going to leave no fingerprints. Now, imagine running to be a judge under those circumstances. It's a pretty chilling proposition. Would everybody have the guts to stand up to an angry rich person who's going to conduct this kind of campaign? So here's an example, and again, keep in mind that question of, is this a express advocacy or its functional equivalent, or are we trying to get an office holder to act on a matter?
Our Oakland County Circuit Court needs new leadership. Prosecutors Bill Rolston and Deb Carley have a plan for the Oakland County Circuit Court. Bill Rolston took on public corruption in Oakland County, and he shut it down. Deb Carley protects our families by prosecuting criminals who would seek to harm our children. Prosecuting criminals and protecting our children. Bill Rolston and Deb Carley. To learn about the Bill Rolston and Deb Carley plan, go to www.therolstoncarleyplan.com.
I'll point out here, this is the same, that one was the same judicial crisis network that did the hit job on Bridget McCormick in the Supreme Court race. The bagman for both of those ad campaigns was the same. Also happened to be the same bagman who worked for the super PAC, Hardworking Americans, that used $1 million of Sheldon Adelson's money to try to kneecap Debbie Stabenow in the last week of that U.S. Senate campaign in Michigan. The other entity here, Americans for Job Security, we last saw it work in Michigan in the 2010 Republican gubernatorial primary. Mike Cox put up a set of ads accusing Pete Hoekstra of supporting a bridge to nowhere. Americans for Job Security had a parallel ad with the exact same talking points. So there is a Michigan connection with the Americans for Job Security, but the common denominator here is that these are nonprofit corporations that are essentially being used as washing machines to scrub fingerprints off of money in these judicial campaigns. This slide, this dashboard, and I did this as a tribute to Governor Snyder, who's very fond of dashboards, is to illustrate that, you know, you've seen in the earlier slide about the history of Supreme Court campaigns. This is not new. This dark money phenomenon is not new in Supreme Court races. It's also not confined to judicial campaigns. In 2010, basically half the money, plus or minus a little bit, was off the books in the Attorney General campaign, Secretary of State, Supreme Court, the Democratic gubernatorial primary, and the gubernatorial general election. The only campaign where clear majority of the money was disclosed was the Republican gubernatorial primary, where now Governor Snyder self-funded $6 million. So that was the source of that accountability. I pointed out in doing this up that both all Secretary of State Ruth Johnson, the leading vote getter in the Supreme Court campaign, now Justice Mary Beth Kelly, and the Democratic nominee for Governor Virg Bernero all won a statewide election without the benefit of their own TV ad. They all were wholly dependent on dark money television advertising. Now, TV isn't the only thing going on. There's a ground game, there's direct mail, there's radio. But TV is where still about 60% or more of the money in a statewide campaign goes. So it was a big factor, and you had these individuals winning statewide election basically as bystanders to their own campaigns. So my message in all of this is that this is a major phenomenon, and to my way of thinking, a major problem, and it's getting worse. I think we've got a winning approach in testing with a request for a new interpretive statement. How can you continue to put all this spending outside the definition of reportable campaign expenditure? But we'll see. What else? Well, I think anybody who runs for office in this state, a constitutional executive or a legislator, should be asked where they stand on this. Justice Scalia made a comment in a case called Doe against Reed, which had to do with a desire for anonymity on the part of somebody who was a petition signer in California's Prop 8. They wanted anonymity. They felt they were being harassed. And Justice Scalia said, you know, this kind of political courage of standing by your political speech is really to be expected, and without it, democracy in this country is doomed. I think Justice Scalia is right. Now, in the Citizens United case, that was the lesser, or the portion of the whole case that got less attention was Part 4, where the nonprofit corporation Citizens United said, well, surely you're not talking about us, a nonprofit corporation, disclosing our donors. And it was an 8-to-1 vote that, yes, we are. And that's perfectly acceptable, constitutional. Now, the US Supreme Court isn't going to write that into law. The Congress has got to do that, or Michigan's legislature needs to do that. But there's no question about the constitutionality of it. And I think we have the right to know whose money is driving election outcomes, because the same money that drives election outcomes drives public policy after Election Day. We need to know whose money is driving the process. And I submit to you, we don't know. And what we don't know is not a bunch of $50 and $100 checks. This is where the 5, 6, and 7-figure checks are aggregated and spent in the political process. We are fools to let this happen to us. So that's the extent of my depressing prepared remarks. If I can depress you any more, I'll try to answer your questions. Yes, sir.
Yeah, I want to be depressed some more. I'm sure somebody has introduced bills in the legislature to require disclosure of who's making these contributions. I assume that has happened. If so, what has prevented them from being passed? What committee are they bottled up in? Why is it not moved?
Well, to back up one step from that, this is what I call the office holder's dilemma. We polled after the 2008 Supreme Court campaign, and 96-3 Michigan voters in this sample said that all the money in judicial campaigns in particular ought to be disclosed to its source. Now, I don't think you can get 96% of Michiganders to agree that the grass is green and the sky is blue. That's a pretty deeply held value, and I think the legislators know it. But on the other hand, you have the funders, and the funders want anonymity. And so there's the office holder's dilemma. The citizens' interest and the funders' interest, and they're going in with the funders. Now, the Democrats will introduce bills right now, but the Republicans own it because they've got the majority, and they're not interested. Now, I'm referring to the last legislature. We'll see what happens. I mean, it's early in this legislature. The House Elections Committee has just had organizational meetings and presentations from the Department of State about how we run elections and so forth. You know, in this regime of enforced inexperience, there's a lot of learning has to go on every time around. And it's not a satisfying or direct answer to your question, and it's a very legitimate question. I think the best approach to it, at least initially, is to ask the more general question of your representatives in the House and Senate, where do you stand on disclosure of this kind of spending? We'll try to see that vehicles are there. I guess I'm not done with my prepared remarks. Mary mentioned I had the privilege and pleasure of working with the Judicial Selection Task Force. It was convened by Marilyn Kelly when she was Chief Justice. Her co-convener was Jim Ryan, who is a former Supreme Court Justice, Michigan Supreme Court Justice, now a senior judge on the Sixth Circuit Court of Appeals, the U.S. Federal Sixth Circuit. And I don't think Jim would mind me telling you he's a very conservative judge. They led a diverse group, liberals and conservatives across the board, business people, people who've been politicians, and there was a consensus in that group that there has to be disclosure in these campaigns. Relevant to our present circumstance, they made another recommendation that the governor should voluntarily assemble a nominating commission to take applicants for judicial vacancies, evaluate them in a public process, and make a recommendation to the governor of a short list from which ideally he'd make an appointment. That idea was brought back up by Jack Lessenberry, the Free Press editorial page, the Holland Sentinel, and a few other, Phil Power, some columnists and editorial pages around the state. That doesn't appear to have traction right now, unfortunately. And it's not just relevant to this Hathaway vacancy. You know, I mentioned it's difficult to knock out an incumbent Supreme Court justice. Think about the Court of Appeals. Our present Court of Appeals, 28 judges, 21 of them first got on the court by appointment. No incumbent Court of Appeals judge has ever lost an election in Michigan. This is as close to a lifetime appointment as you're going to get in Michigan. So I think that's a relevant idea. A couple of the other things, just to round out the representation of the task force work, is they suggested that we have a constitutional provision that judges cannot begin a new term or be appointed to a term after they've reached age 70. Well, in this age of longer life expectancy, more robust health, and I would hope a rejection of age discrimination, that really doesn't belong in our Constitution. Now that's one where the Senate Judiciary Committee has passed unanimously a joint resolution. We'll see how it does in the whole Senate and if it gets any traction in the House. But you know, in the big scheme of things, with what our problems are, that's small ball in our whole judicial selection thing. There's a recommendation that there should be some kind of campaign oversight committee to make the kind of observations I did, that yes, Bridget McCormick fought for a convicted sex offender who happened to be innocent. Those are the details voters should know about as they view these kinds of things, and that there somewhere be a voter guide so we can get factual information about who these people are, what they've done over their career, because it's not easy to come up with that kind of information in a place where you can do side-by-side comparisons of who they are and what they do. So that's what I say about this. We have links to this report in electronic form on my website, mcfn.org, and on the League of Women Voters of Michigan website, so you can learn more about that. But to your point, I mean, you're hitting right at the heart of it. This is a deeply held value of Michiganders, conservatives and liberals alike. I mean, if you ask conservatives and liberals, they'll tell you they believe in transparency and accountability. I know they will, but we're not getting it done. We're not even close to it. We're having a giant money laundering and fraud scheme perpetrated on us as voters in this state.